you are if you are a victim advocate, we hope you stay on. Please don't hesitate to put questions in the chat, and we'll get to them as we can. If we don't see them, because it's just Marlon and I, and um, we're trying to monitor a lot of things. Please call them to our attention again, and we'll try to get to it, because we don't want to miss anyone. Next slide, please. So we do this work with the support of a grant from OVW. The findings, conclusions, and recommendations expressed today are ours, and they don't necessarily reflect the views of the U.S. Department of Justice, Office of Violence Against Women. Again, my name is Suzanne Garcia. I'm an attorney. I started out in legal services, and then I went to work for a nonprofit that provided free civil legal services to survivors of domestic violence in really rural areas. And I was practicing in both state courts and tribal courts. And then I went on to be in-house counsel for a tribe where I was also doing a lot of program development, code writing, and also appearing in court for the tribe, both in tribal and state courts. And I've been lucky enough to be at the Tribal Law and Policy Institute for a little over 10 years now. So we're really happy to be here. I'm joined by Marlon, who I couldn't do this work without. He's going to help with all of the tech-related things and help keep me on track and help me. I'm going to be monitoring for questions, but he's also going to help me do that. Okay, so today I'm going to give a really high-level overview of the basics of inherent sovereignty, civil jurisdiction, and criminal jurisdiction. As you know, each of your cases are going to be unique. Each Native nation is diverse in how they've asserted their jurisdiction and how their lands are held. They might be exercising special criminal jurisdiction, and they might not be. Their lands might be checkerboarded, and again, they might not be. So in addition, the context within which you practice is going to be unique. You might be in a public law 280 state. You might be practicing close to other jurisdictions, and you might face a common issue like I used to, where a party will run to another jurisdiction and file there. So given all this diversity, what I'm going to try to do today is speak very generally and draw your attention to areas and issues that can affect your local practice. The goal is to call your attention to these things and give you resources to support you in your local work. During future webinars, Kelly, Bonnie, and I are going to be providing specifics on things like protection orders, confidentiality, divorce and custody. So you'll get more detail in future webinars. So today is just a real high-level overview. As always, if you have specific questions, please don't hesitate to reach out to us. Our contact information is included in the slide deck, and the presentation will be available on our webpage shortly. Next slide, please. Okay, I want to check for questions. I don't see any. Hi, everyone. Good to have you here. So 2 points while we're on this slide. First, you're going to hear me use the term Indian a lot today because that's how it's written into federal law. It's not a term I use on a regular basis, but we're using it today because that's how a lot of the federal code is written. Second, we're giving you this definition of Indian country because so much about working in this area depends on where acts happen and where people reside. So knowing this definition is going to be essential to your work. Next slide, please. We are going to be using history to frame the first part of this presentation because otherwise, as Felix Cohen puts it, it can be a mystifying collection of inconsistencies and anachronisms. Throughout the history of the United States, there have been shifts in policy and how tribes' inherent sovereignty has been viewed. So framing it in this history helps explain these inconsistencies. On a side note, if you don't have this book, if you don't have Felix Cohen's book, which has been updated, I would suggest getting it because it covers a lot of ground and really gives some really good background. Next slide, please. Okay, topic one is tribal sovereignty. Inherent sovereignty isn't well defined in black letter law, so we have to look at practice and other descriptions. This one from the National Congress of American Indians, like other sources, emphasizes that a tribe's inherent sovereignty is especially strong when it's protecting and enhancing the health, safety, and wellness of its citizens. So it's especially strong when it comes to protecting survivors in the community in which they live. Next slide, please. But the boundaries of that sovereignty is going to depend on the specific context of the tribal law, state law, local history, and local practice. The second topic on this slide begins our discussion about how inherent tribal sovereignty is recognized in three ways in the legal structure of the United States. The inherent sovereignty of tribes was recognized from first contact. Tribes were understood as sovereign entities to be negotiated with, and so treaties and agreements were signed. Importantly, the passage of time does not affect the relevance of these treaties, and the Supremacy Clause makes them the law of the land. Next slide. Thanks, Marlon. Tribes' inherent sovereignty is recognized in two more ways. It is baked into the Constitution at Article 1, Section 8, which outlines Congress's role. And it says that Congress shall have the power to regulate commerce with foreign nations, among the several states, and with Indian tribes. It's also long been recognized in case law, starting with the Marshall Trilogy, the three cases that are mentioned here. And again, I'm not going to go into these cases. I just want to draw your attention to them and how the sovereignty of tribes has been recognized for a very long time. Next slide, please. So for the next 4 slides, we're going to get into that history. There's a lot of information in these slides, and we're not going to be going over everything. We left it in there intentionally to support your future research and to provide some context. So for this part of the presentation, I'm going to highlight events that affect sovereignty. And we've already kind of gone over the eras in this slide and the events that affected sovereignty that are on this slide, so I'm going to move on. Next slide. Okay. So things to note on this slide are Ex parte Crow Dog and the Major Crimes Act, because they affect tribes' criminal jurisdiction. In Ex parte Crow Dog, the Supreme Court held that the murder of one tribal member by another tribal member in Indian country was within the sole jurisdiction of the tribe. And so the Supreme Court held that federal territorial courts had no jurisdiction over the case. Congress reacted in 1885 by passing the Major Crimes Act, declaring that major crimes, and there's a list of them, committed by a Native person in Indian country was a federal offense that could be heard in federal court. So here we see a little shift from recognizing sovereignty very broadly to some limitations being placed upon it. Next slide, please. Then we move into the allotment and assimilation era. Things to pay attention here is the General Allotment Act of 1887, also known as the Dawes Act, which has resulted in land patterns known as checkerboarding. It authorized the president to allot portions of reservation land to individual tribal members. And once those allotments were made, the remainder of the lands were open for non-Indian settlement. Because jurisdiction is tied to how the land is held a lot of times, determining who has jurisdiction in a case can be very difficult if the land is checkerboarded. So this is something you're going to want to know is how those, you know, how the tribes you are working with, how they hold their lands and what the land patterns look like, because this could be something that you might have to address. In Talton v. Mays, a United States Supreme Court case, the United States the Supreme Court held that the United States Constitution does not apply to tribal members' interactions with their tribal governments. And then we go to the Indian Reorganization Act era, which presents a shift back towards sovereignty. So passage of the Indian Reorganization Act of 1934 resulted in many tribes setting up written legal structures for their governments, including constitution. The Indian Reorganization Act, or IRA, also ended allotments. So here we have a shift towards sovereignty. Next slide, please. But then we move into the termination era. And to say that the termination era represented a huge shift away from respecting tribal sovereignty is an understatement. So during this era, some tribes' legal relationship with the United States government and their status as a tribe was terminated. And this is why some of you will be working with tribes that had their recognition reinstated at much later in history. And it's going to be really important for you to understand those boundaries of history as you're serving survivors of domestic violence from those tribes. Also during this time, Public Law 280 was enacted. So Public Law 280 extended state criminal and some civil jurisdiction into Indian country. So not only did this change jurisdictional boundaries, it impacted resources such as those for law enforcement because the extended jurisdiction did not come with extended resources. There are 6 Public Law 280 states, but as with everything, there's exceptions. So the Public Law 280 states are California, Nebraska, Minnesota except for Red Lake, Oregon except for Warm Springs, and I believe Umatilla. And a side note on that, last year, Oregon passed legislation formalizing a process for retrocession, which is a process for the state and the tribes to work together to remove that state jurisdiction. So I think it's going to be it might be a very much a moving target in the state of Oregon. If there's someone on who practices in the state of Oregon, I'd love to know more about that and what you're seeing. Okay, so the other Public Law 280 states are Wisconsin and Alaska, except for Metlakatla. There's other exceptions that I know aren't listed here. I've seen some folks on from Nevada Legal Services. And I'm pretty sure that Ely is still Public Law 280 in that section, but it's been a while since I practiced out there. So even though they say there's the 6 Public Law 280 states, okay, so I got it right. Yeah, thank you, Ilse. California, absolutely. There's variations. So getting to know the tribe that you're going to be whose court you're going to be practicing in is going to be really, really essential to know if there's Public Law 280 involved or not, because you can't rely on the 6 Public Law 280 states because it's very much in flux. Okay, so we shift from the termination era, which was an era that definitely impacted tribal sovereignty, to the self-determination era, which I think, okay, Wisconsin is Public Law 280 except for Menominee. Thank you, Jerry. The self-determination area is another shift in policy. So by the late 1960s, self-determination policies were regarded as a failure, and the theme of supporting self-determination and self-government became more common. Excuse me. During this time, Congress passed the Indian Civil Rights Act, or ICRA, in 1968. So under ICRA, remember I told you in Talton v. Mays, the Supreme Court said that the United States Constitution didn't apply to tribal members' interaction with their tribal governments. Under ICRA, tribal members are protected by some, but not all civil rights in the United States Constitution in terms of their interaction with tribal governments. Notably missing for our purposes is there is no right to indigent defense counsel in criminal cases. Unfortunately, ICRA also limited tribal courts' criminal sentencing authority to the maximum of 1 year, which, as you can imagine, severely hampers their tribe's ability to respond to serious and repeat offenders. Supreme Court cases. Sorry, I'm keeping an eye on chat. It's good to know that there is a lot. So what I'm hearing here is, although Washington is not a mandatory state, whether or not Public Local Law 280 applies varies by tribe. So that's good to know. So again, there's a lot of diversity in the work that we do. And so in knowing these details are just going to help you better support and provide services to survivors of domestic violence. Okay, back to the presentation. So we're in the self-determination area, but the Supreme Court cases in this era put boundaries on tribal courts. We have Oliphant, where the Supreme Court decided that tribes have no criminal jurisdiction over non-Indians for crimes committed in Indian country. We have Montana, where the Supreme Court held that tribes have no civil jurisdiction over matters involving non-members arising on fee land in Indian country, with 2 exceptions that we'll get to in further presentations, additional webinars. But it's the overarching thing to understand is that with Montana, no jurisdiction over non-members unless there's one of the 2 exceptions. Kind of pushing back against the Supreme Court decisions that caused huge problems for tribes who were trying to protect their citizens and protect their communities. We have the Violence Against Women's Act of 2013 and 2022. And this allows, this is their voluntary programs, and tribes that have resources can choose to operate criminal justice systems that allow them to charge non-native offenders of certain crimes. Okay, I covered a lot. So I'm going to stop here for a moment to check in on whether people have questions, or we were curious to know whether anyone online has been part of implementing either the Tribal Law and Order Act or the Special Criminal Jurisdiction under the Violence Against Women's Act. So I'm going to pause here. Certain tribes. I'm sorry, can you elaborate a little bit more on that question? Coyote Valley. Okay. Well, if you for certain crimes, yes. So under VAWA, there's a list of crimes, and we're going to be getting to that later in the presentation. That there's under VAWA, there have to be for the special criminal jurisdiction. VAWA changed who can be charged and it changed what can be charged. And we'll be getting to that at the end of the presentation today. So stay tuned. All right. Next slide, please. Okay. Um, yeah, it is. It is fairly unbelievable sometimes. So thank you. Agreed. Um, okay, so for this next part of the presentation, I'm going over, again, a real high level overview of civil jurisdiction. Um, so given all the factors that are going to impact it, I'm just going to try to make 5 basic points that I'm going to list out here very briefly. Um, in to support your practice, I think it's going to be really important to look at how the tribe has exerted its jurisdiction. That's your first stop. Look at the tribal code. How has the tribe asserted its jurisdiction? Is it implementing the Tribal Law and Order Act? Is it implementing special criminal jurisdiction? How has it said what situations is it's going to cover? Um, Second point that it's going to be important to, as a takeaway from this presentation, that is if the custody of a child is involved, know the Uniform Child Custody Jurisdiction and Enforcement Act, also known as UCC-JEA. If it has to do with the protection order, look to the Violence Against Women's Act. And if there is no custody issue and the case does not involve a protection order, remember Montana. Fifth, understand local practice, but also be prepared not to agree with it because everybody interprets laws differently. When I was practicing, I had a case and it was in state court and it clearly belonged in tribal court. Um, Small rural jurisdiction. I walk into the courthouse and the judge looks at me and he's like, Miss Garcia, what are you doing here? This is the way we've always done it. And it's like, well, Judge, I'm sorry, but the way you've always done it is wrong. Because the property that they were talking about was tribal property and tribal land, and both the parties were tribal members who lived on the reservation. So know what the local practice is, but please be prepared to push back if it's not in line with inherent sovereignty and the laws that we're kind of talking about here. Okay, next slide, please. So again, the first thing you're going to want to do to understand civil jurisdiction where you practice is, not surprisingly, look at the tribe's code and understand how it's asserted its jurisdiction. You also want to consider the status of the parties, if Montana and its exceptions come into play. And you'll also want to know if you're practicing in a public law 280 jurisdiction to know if the state can claim jurisdiction as well. Next slide, please. If the custody of a child is at issue, you should know whether Section 104 of these UCC-JEA is recognized by the state. The UCC-JEA's jurisdictional standards have to do with residence of the child and how long they've lived at that residence. However, you're going to have to read this within the context of how the tribe has exerted its jurisdiction, because they might not have that residency rule. So you're going to have to kind of go back and forth on that. Next slide, please. So Rihanna has a comment in the chat where she reached out to the Law and Order Committee and asked them to discuss a process for filing first and defining jurisdiction over children in custody cases. And I think that's really a good idea because especially if you have people who are new and they might not understand what that process is, You're just going to be able to better protect um, your clients and their families and the community if it's all very clear instead of trying to remember how you've done it before or coming up with a process. Yeah. So Jerry says that, several tribes in Wisconsin exercise jurisdiction over children who are present on the reservation, um, whether they're tribal members or eligible for enrollment. Right. So, and I've worked in those jurisdictions as well. It's like, well, okay, state, you might have your residency rule, but we don't necessarily. If the children are present on the reservation, we feel like we have an obligation to protect them, and so that's what the tribe does. So that's what I mean about the going back and forth between UCCJEA and how the tribe has asserted its jurisdiction. Okay, so we're talking about protection orders here. Um, on this slide. And so the next webinar is going to be about protection orders. And Kelly's going to give you a lot more detail than I'm going to give you today. But for the purpose of today, know that the tribe should have full jurisdiction to issue and enforce protection orders involving any person and this is under VAWA, in matters arising anywhere in the Indian country of the Indian tribe. So if the matter arises outside of Indian country, if the thing that the person feels the need to be protected from arises out of the tribe's reservation, you might have to consider Montana. Next slide, please. So speaking of Montana, here are the rules of civil jurisdiction as they stand today. So if you're a member Indian and the tribe is wanting to assert civil jurisdiction over you, it's pretty broad, pretty expansive, and generally exclusive except in Public Law 280 states. If the tribe wants to assert jurisdiction over a non-member Indian, it's more extensive than over non-Indians, but more limited than over members. But in civil matters, non-member Indians can be treated similarly to non-Indians. If the tribal court is going to be asserting jurisdiction over a non-Indian, it's presumptively limited. The civil authority over non-Indians is limited unless their activities fall under one of the two Montana exceptions. And those are very quickly whether the person has entered into a relationship or an agreement with the tribe. And second is if the person and their actions represent a threat to the health, safety, and welfare of the tribe. And just know that the Supreme Court has viewed those exceptions in a fairly limited manner. And so it might be important to lay out your arguments very in detail when you file in tribal court. Okay, I'm going to take a second here to field some questions. I've been keeping an eye on the chat, and I think we're up to date. All right. Next slide, please. Okay, so now we're going to talk about criminal jurisdiction. I'm mostly going to focus on tribal jurisdiction in these cases, just because that tends to be the focus of this project. But I will bring in a little bit of Public Law 280. Next slide, please. Okay, so here's the overview. Um, the scope of tribes' criminal jurisdiction has gone through restrictions and expansions, as we discussed earlier in the history portion of this presentation. Um, we go from recognition of tribal sovereignty at first contact, with tribes handling matters in their own way, um, under their own, how they would handle things. And then you've got ex parte Crow Doc, um, and the Major Crimes Act, which layered federal jurisdiction over major crimes over that tribal jurisdiction. The Indian Civil Rights Act reduced tribes' sentencing authority, to make it pretty toothless when it comes to addressing serious and repeat offenders. And then you've got Oliphant, where it was decided that tribes do not have criminal jurisdiction over non-Indians. But then you've got VAWA and special criminal jurisdiction, where some tribes have been able to take back jurisdiction over non-Indians in some cases. The result from all of this is a jurisdictional maze, kind of leaving Indians and non-Indian survivors alike vulnerable. So I'm going to try to tease some of that out in the following slides. Next slide, please. Um, like with civil jurisdiction, your first step is going to be to understand how the tribe has exerted its jurisdiction. We're talking about domestic violence here. So it's going to be important to know whether the tribe has implemented the Tribal Law and Order Act and if it has implemented special criminal jurisdiction under VAWA. You're also going to want to pay attention to the status of the people involved because that's going to affect jurisdiction. Next slide, please. So Marlon has a good question here. So he's wondering if anyone who's participating today participated in any code revisions or code writing for your tribe or the tribe with who you are working. So Rihanna, are you working on Tribal Law and Order Act or criminal jurisdiction? I'm sorry, the special jurisdiction under VAWA? Okay, probate code. Um, this was so the Tribal Law and Policy Institute has a ton of code drafting resources, especially in this area. Um, and one of them has to do with the special tribal criminal jurisdiction. And they just came out. Um, and we will be putting links to those resources in the chat near the end when we're talking about evaluation and stuff. That'll give me time to go over there and get the links for those resources. So I highly recommend those. Okay, so criminal jurisdiction is so complicated in Indian country that people make charts to keep everything straight. It's also kind of a moving target because there's been some Supreme Court cases that have affected tribes' criminal jurisdiction and what the state's role is and how that's going to play out is really remains to be seen. So this is something that to keep an eye on. And I would recommend TLPI's listserv because there's a lot of good information about what those changes might be. Okay, so I kind of broke out the chart into the different PowerPoint slides because the chart's enormous. and no one would be able to see it if I kept it all on one slide. So first, we're going to walk through the non-public law 280 states. So this slide has a native offender and either a non-native or native victim. So this is a native offender and either a non-native or native victim in a non-public law 280 states. In these cases, the tribe probably has jurisdiction depending on the crime committed. Whether or not the federal courts have jurisdiction is complicated, and it's beyond the scope of this presentation. So just note that that's a really complicated and kind of gray area of law. Next slide, please. Again, for a non-public law 280 state, here we have a non-native offender and a native victim. If the tribe has opted into special criminal jurisdiction, they may have jurisdiction. If they haven't opted in, under Oliphant, they don't. Again, it's complicated whether or not the federal courts have jurisdiction, and it's kind of up in the air when it comes to whether or not the state has jurisdiction, given the Supreme Court case of Oklahoma v. Castro Huerta, which is from 2022. So we're still all kind of seeing the way it plays out. So stay tuned on that one. Next slide, please. Okay, again, non-public law 280 state. We have a non-native offender and a non-native victim. Here again, if the tribe has opted in and is especially exercising special criminal jurisdiction, depending on the crime, they might have jurisdiction. Under McBratney, another Supreme Court case, the state also might have jurisdiction. Does anyone have any questions before I move into Public Law 280 states? Okay. Moving on to Public Law 280 states. Walking through the charts again. Next slide, please. Okay. So this is a Public Law 280 for Public Law 280 jurisdictions. And as we just kind of discussed, that can be very specific. Don't count on being in a non-public law 280 state or a public law 280 state. There's a lot of diversity here. This slide has a native offender and either a non-native or native victim. In these cases, the tribe probably has jurisdiction depending on the crime committed and how they've asserted their jurisdiction and what their code looks like. The state might also have jurisdiction. So this is a case where you're going to want to know about local practice. When I was practicing in a public law 280 state, law enforcement and the prosecutors would, they were probably working on these cases together. They were probably aware of the cases together. And so they would get together and decide who was going to charge. So this is where knowing about what that local practice can look like. Even if you only work in the civil realm, I think it's important to know that because your goal is to protect your client, right? Your goal is to protect your client and their children. So you're going to want to know what accountability is going to look like for the offender. Next slide, please. So this again, Public Law 280 state, non-Indian offender, native victim. If the tribe has opted in to the special criminal jurisdiction, they might have jurisdiction. If they haven't opted in under Oliphant, they don't. The state, however, will. Next slide, please. This slide represents a non-native offender and a non-native victim. So here, again, if the tribe is opted in and is exercising special criminal jurisdiction, depending on the crime, they might have jurisdiction. And the state will have jurisdiction. Next slide, please. Okay, so we've kind of talked about criminal jurisdiction under the Violence Against Women Act. And I told you that we were going to get into which crimes were covered. So this is where we're doing it. Okay, so tribe's criminal jurisdiction was first recognized in VAWA 2013 for victims of domestic violence, for covering interpersonal violence related crimes. But then in 2022, that jurisdiction was expanded. So it went into effect October 1st, 2022, built on the framework from VAWA 2013 to expand tribal authority to prosecute specifically non-Indians in tribal court for certain crimes. But the tribes have to opt in and they have to meet certain requirements. And it takes a lot of resources for tribes to opt in and to meet those requirements. So this is something a lot of tribes, I think, are kind of struggling with because they would like to assert this jurisdiction. And the Tribal Law and Policy Institute is working very closely with an intertribal work group that is talking about what this is going to look like and how it's going to look like. And that group has a lot of information, a lot of experience, a lot of data. And so I highly suggest or recommend that looking at some of the resources that TLPI has online and some of the reports and things that have come out about that. But VAWA 2022, it changed, like I said, what can be charged in some cases and who can be charged in tribal court. Next slide, please. So here's a list of the crimes that can be charged in tribal court if the offender is native. So this was a game changer. So it's domestic violence, dating violence, protection order violations, sexual violence, stalking, sex trafficking, child violence, obstruction of justice, and assaults against justice personnel. And collectively, these are referred to as the covered crimes. Next slide, please. So like I said, it changed who can be charged in tribal court. It clarifies for cases involving obstruction of justice or assaults against tribal justice personnel by a non-native. If the victim is also non-native, which happens a lot because you have people working for the tribe who are non-native, the tribe still can have jurisdiction over those cases. And this is a big shift. It also, 2022, removed the existing requirement under VAWA 2013 that limits tribal jurisdiction to those non-Indians who live or work in Indian country of the tribe, and the qualifying relationship with a member of the tribe or non-Indian resident. So it used to have to be sufficient ties in order for the tribe to assert jurisdiction in these cases, and that requirement was removed in 2022. Next slide, please. Importantly, what VAWA 2022 does not cover, it's cases where the victim and the defendant are both non-native, except in cases of like assault of tribal justice personnel or obstruction of justice. Um, it also does not cover crimes that take place outside of the Indian country of the participating tribe. Next slide, please. All right. So we've been fielding questions as we went, but now we'd like to open it up to see if people have any questions or kind of thoughts or reflections on the materials we've presented today. Y'all are quiet. We'll have plenty of time for questions. Marlon put a really good question in here. Okay, there is data on which tribes have opted in to the special criminal jurisdiction. I don't have it at my fingertips right now, but we can get that to you, Elizabeth. I think Marlon, because Marlon's worked with the intertribal work group, so I think he's actually more up on this than I have. And yeah, and I think NCAI, so NCAI and Tribal Law and Policy Institute are working closely on this. Marlon, do you remember how many tribes have been successful in asserting the special criminal jurisdiction?
That's a great question from the audience. And just to give a little bit more information, I do work on our OVW-STCJ TA services. And previously, I dropped a link to tribalvawa.org. And for folks who are following along live during the podcast, if you go to the Implementing Tribes tab, we have a map that has drop pinpoints of the geolocations of tribes who are in stages of implementing. This again, uh, implementation it also includes VAWA 2013 and VAWA 2022. And in that same tab, I believe that we currently have 38 tribes listed in various stages of implementation. If any of the participants today know that their tribes have implemented, please feel free to email myself or Suzanne, and we can pipeline any of those updates as needed to the OVW STCJ team. And also, Judge Kelly Stoner, who will be presenting on the next webinar, she also has a little bit more intimate knowledge about our implementing tribes. So again, that website for those who are listening is www.tribalvawa.org.
Thanks, Marlon. I've been to a couple of those meetings, and there's a lot of really good, really thoughtful discussion about how the requirements for the special criminal jurisdiction are going to be met, um, um, successes and challenges. And it's a really great group that works together and just brainstorms. It's some of the best minds and hearts doing this work are getting together and trying to move it forward because we've got, okay, help me out here, Marlon, 576 tribes in the United States. Um,
I believe so. We have the Department of Defense, some tribe that was just added,
yeah, yeah,
Lumbee.
right, right. Um, so, um, only 38 have been successful in asserting this jurisdiction, and I know one of the tribes that I was working with, it was finding incarceration options for the offenders. So there's a lot to it. Jerry says about cooperative agreements, mutual aid and backup for law enforcement. Um, I don't know for a fact that it's a common practice. I know it was a common practice where I worked because we would have issues with fresh pursuit. So um, um, someone would decide to run and because the county sheriff was after them, and of course they'd head straight for the reservation because they thought that they would be able to get away with it if they did that. Um, and so part of the agreement with law enforcement, and also we had a better drug dog, honestly. We had the best drug dog in the area. And so that backup and mutual aid was just essential, and also to keep the tribal community safe because once word got out that you couldn't just run through the reservation to get away from the county sheriff, that really went down. That practice went down. So, and there's probably, I know the Tribal Land Policy Institute has a web page about state and tribal collaboration. I think Walking on Tribal Ground, and they probably have some resources about that mutual aid. And so I'll take a look for that and see if we can get it to you, Jerry. And here's Nevada Legal Services again. So yeah, Reno Sparks has a similar agreement. Okay, sure. Do we have any other questions or discussions that things that people are wondering about? Because we have the time um, to go through them today. And we want this to be more of a discussion than a presentation. I know it was very legal heavy here. Ooh, sovereignty from jurisdiction. Okay. Um, and folks in the room, please help me out with this if you disagree with me or if you agree with me. Sovereignty is a tribe's right as a government. And I put that in, as a governing entity. Um, and it has to do with more than the court asserting jurisdiction. So to me, jurisdiction is more narrow. It's what the court has asserted, what the tribe has asserted that its tribal court will hear. Um, whereas sovereignty has to do with a lot of things. It has to do with protecting its community. It has to do with protecting its lands. It has to do with protecting its culture and its resources. So it's much broader than jurisdiction. There's probably statistics available for Toloa. I'll take a look for that, Rihanna. It is a difficult definition. That was a good one. All right. Okay, so Marlon, do we have evaluation and other resources? Okay. Oh, so our upcoming webinars. Next week, Judge Stoner, Kelly Stoner is going to be discussing, and Bonnie Claremont, who we're missing a lot today, is going to be applying for and drafting enforceable tribal protection orders. It's a terrific presentation. Has to do with legal matters as well as practical matters, based on her experience. Um, and then the webinar after that, I think so that's going to be the 21st, and then the 28th is going to be privacy, confidentiality, and privilege issues when attorneys and advocates work together. And that's, again, going to be another terrific one that Judge Stoner is going to be doing, because those can be thorny issues. but important ones when you're trying to protect your client, their family, and their community.
And as a matter of housekeeping and a friendly reminder for those of you who are participating in today's webinar, please feel free to use the same link for those two upcoming webinars that we'll be hosting. And if you have colleagues or other friends of your community who could benefit from any of these topics, please feel free to send those registration links over to them. In the Q&A, we did get a question about materials, specifically accessing the PowerPoint deck. We will be sending a PDF version to attendees on today's webinar. And also as a little preview plug for folks who don't know, we're currently under OVW review for our website, which we hope to be a storing ThinkPad launch, central location for all our recordings, materials, other useful information. And when we get OVW approval, we'll be sure to send that out as well. Chelsea also did have a Q&A question, Suzanne, and the question is, are you able to view the previous webinars in this series anywhere? As I just shared, our website is currently under review, but if you send us an email, we can forward those links to both the PDF hyperlinks and also to the YouTube links for those viewings.
And I just like, while we're on this slide, I'd just like to say, like, we say this is the legal services track, but the bigger goal of this project, of the TLAPS project, is to really support collaboration between attorneys and victim advocates. Um, for some of these questions about jurisdiction and local practice, I would really be leaning on my local victim advocate to help me understand those things, especially if I was new to the jurisdiction. So please, if you're a victim advocate, please attend because it's great to put all of our heads together for this. Here's our contact information. This is the TLAPS team. So we have our individual emails here, but also we have the tlaps@tlpi.org. That goes to all of us. And we all try to pitch in and answer as quickly as possible. Marlon mentioned the website that's going to be live, we hope very soon, triballegalservices.org, and the TLPI website, which is going to be your portal to all of the information and resources that we talked about today, the code development series, the intertribal work group, state tribal collaboration having to do with cooperative agreements between law enforcement on a number of matters, and also about protection orders. There's a lot of resources there. So we invite you to dig in. And here we have the evaluation link. Please let us know how we're doing and how we can improve, because we want to be of service to you. Marlon, did you want to add anything about the evaluation?
As a friendly reminder, we'll be sure for those who had to click off early to send the evaluation link in our summary email post this recording. If you have time, we'll leave this screen up for a little while for others to go ahead and click through. If you're viewing the webinar full screen on your device, we also included a QR code. You can use your phone to go ahead and use your device to complete that evaluation for today's session.
I'm trying to drop resources in here. Let's see if it works again, because the link didn't work. Like I said, we've recently come out with a sample code and a code checklist for implementing the special criminal jurisdiction. Let's see if this, nope, that's not going to work. My hyperlinks aren't working, Merlin. We will get them out to you. Apologize. This is where my technical abilities fail.
And for those folks, just to echo something that Judge Stoner or other STCJ team might offer, the resources for those tribes who are in the beginning stages of considering implementation. They could also be used as a preview about, as Suzanne had mentioned earlier in the presentation, requirements, issues like jury pool issues, posting your legal code or making your legal code available for others, all of those in the weeds issues. And so in sharing out our checklist that was recently published for implementing tribes for updating codes to implement VOW 2022, those can also be used for non-implementing tribes. And for tribes that work on off-reservation lands or outside of Indian country, those are definitely good materials to look at to see what survivors who they support as tribal members also face in their keyword today, sovereignty. Just double checking the Q&A
I don't
for you,
see any
Suzanne.
more.
We
No?
don't have any Q&A questions.
Okay.
So I'm going to go ahead and pause or stop the recording,
Okay.
and we'll leave this screen up, and I'll make sure to drop in some links for folks who want to stay on to get those hyperlinks available.
Thank you. All right. Thank you so much, everyone, for joining us. We hope this was helpful.